Isn't that a little awkward, though, that we would think that the APA or whatever precludes 1331 jurisdiction to resolve these claims, but it doesn't preclude all Writs Act jurisdiction in the district court to bring these claims? I mean, what if Mr. Clement had simply styled this as a mandamus petition, suggesting that the FTC had acted wholly without jurisdiction, which is a classic mandamus argument, because of all of our mountain of precedent with respect to 2 layers of removal?
He certainly could have made that argument.
And so then we would have been in district court, and that would have been okay.
No, first, the mandamus petition would have had to be filed in the Court of Appeals. That is, the 1651 authorizes courts to issue writs in aid of their jurisdiction, and we've cited a couple of cases.
So he would have been in the Court of Appeals, but he could have gotten to a court immediately. But he would agree to raise his claim if he had simply styled it under the All Writs Act rather than under 1331.
The only claim that he could have raised under mandamus would have been that he had a clear and indisputable right to this relief. And I think that even—
Well, I think that's the nature of his argument, that the 2 layers of removal is clear and indisputable.
It can't
Let's suppose it were. He could do that.
Oh, if it were clear and indisputable, if the court in Free Enterprise Fund had said, and our holding about double for cause removal applies to adjudicative officials as well, he would have a clear and indisputable right to relief. Now, the court in Free Enterprise Fund did the opposite of that. It said, we are specifically reserving the question whether adjudicative officials are to be treated differently. Mr. Clements may win on that argument in the fullness of time, but I don't think he could plausibly have told a court of appeals on a request for mandamus that he had a clear and indisputable right to that relief.
Why does the APA preclude 1331 but not all writs?
Again, I don't think of it as the APA precluding. The APA confirms the inference that the Court of Appeals is the only court to exercise review. And in general, the Court of Appeals jurisdiction is limited to the final cease and desist order. But we cited 2 cases at page 50 of our brief that say, when the All Writs Act refers to issuing writs in aid of your jurisdiction, that can mean not only an actual pending appeal, but a potential appeal. And so the court that could review the cease and desist order has a form of ancillary jurisdiction to superintend the administrative process to the extent of being able to step in if there is really an egregious deviation from appropriate practice.